Hello, welcome to the paralegal counseling training. This is Dr. Tulipo Mwenfumbo. We continue with the law of tort, and today we are going to conclude on looking at the general defenses in tort. The law of tort is a critical law to prove for both the plaintiff and the defendant, in that it must fall under the common law, where the judge has to decide by looking at the testimonies that both parties have given. There is a guideline, though there is a guideline on how the judges should decide on the matter or the tort matters. The judge looks at probability in most cases and applies the law that suits the circumstances. So, as we said, the law of tort, it is a challenge because it is so wide. So, anything that one is aggrieved of or one is injured can claim can institute the lawsuit. Now, that is where the complication comes about, because some cases in the law of tort may be unique and different. So now, how should one defend, or how should one bring the issues before court as in the law of tort? For example, someone has passed through my yard and I'm not happy about that, and I want to sue that person for passing through my yard. So how will the judge judge that circumstance? So, or how will the defendant defend himself in such circumstances? So that is where the law of tort becomes critical. So there must be some things that has to be taken in the law of tort, or there must be some defenses or the evidences that has to be brought before the court. And also there must be on the side of the plaintiff, he has to bring across to the court how he was affected and why he feels that he has been harmed or he has been injured in one way or another. And also the defendant must be able to prove to the court that no harm was done, or the harm was done in a certain circumstance that this person had no power over it. So now, there must be the foundation of tort cases. So in the foundation of tort cases, the plaintiff should state the injury, harm, a loss, or detriment in fact that he or she has suffered. So the plaintiff must bring this to court, that he really has suffered the harm or an injury or detriment, and it has to be factual, and there must be some tangible. He has to be able to prove to the court that really the damage has happened. Under tort, an injured party brings a civil lawsuit to seek compensation for wrong done to the party or to the property. So in this case, the plaintiff should prove to the court that the incident has really caused harm or injury. So that should be the foundation, or in the swing in the law of court. Number one, there must be the plaintiff must state the injury, harm, or detriment in fact that has occurred to him or her. Then the plaintiff should prove to the court that the incident has really caused harm or injury to the party. Now let's look at defenses. So I categorize the tort cases in four categories. Now I want to look at the general defenses in every category that I stated. So now, category number one, defense in unintentional tort. So in an intentional tort, there are defenses that you have to bring before the court. Like there is the act of God. So an intentional torts are those torts whereby one is injured, or it's there are accidents or what is called negligence torts. So now, in these torts, there is what we call, when you are defending yourself, you should bring across by saying this was an act of God, which means it was an avoidable accident. The harm caused by sudden or unexpected physical problem of defendant, lightning or storm. So when there is an injury has been caused because of the natural forces, which is maybe it may be the injury, or it may be the lightning or the storm. For example, one is renting a building to you. Then that building is struck by a lightning. Then this person claims for compensation for the damage that has been caused because you have been staying in his property. So in that case, you use the defense which is called the act of God. You had no control over that situation, so it will be very unreasonable for the plaintiff to claim damages on something that you had no control of as the landlord. Then there is also what is called not feasible. If the injury was not reasonable feasible, you cannot be held responsible. Feasibility means whether a hypothetical or reasonable person would have foreseen damage in the circumstance. So when we say unforeseen disable, we are talking about a circumstance whereby you are very blind. It's like that thing, you have no idea of how the situation can happen. You see? So like I had an incident whereby my house got fire because of electrical surge. Now, in such a case, the plaintiff, the landlord, I cannot sue the landlord, although there were suspicions of bad wiring. But I cannot sue the landlord in the sense that that circumstance was unforeseen. It was not something that was negligence on the side of the landlord or on my side. So it will be very unfair because I was living in his house. Then there is this unforeseen circumstance whereby there is a bad wiring which was not seen. And that brings about the house to be, you lose properties because of that. And who to blame? That can be considered also as a natural thing or unforeseen circumstances or not feasible thing. Then the other one, it is there was no contribution to negligence. Here is a situation that you have not contributed to negligence. The injured person where the injured person contributed to negligence. For example, when you are going for an operation, you sign the document. You sign that this is the risk undertaking. Then something happens, so you cannot hold the doctors, although they are held responsible for their action, but you cannot hold them because you were also you contributed on that matter, like whereby I take my TV for repair, then there is I've contributed in one way or another in the negligence of that incident. So there is a part that I've played that the damage be done. So that is also, it can be a defense where you say that, no, on this matter, though the plentiful is saying that I've done this, but the plentiful was with me. We were together when this incident, he was holding it as well. So now, just because, like, I am the I am the mechanic, then the plentiful is there, is there. Then we are helping each other. Then something happens. Then this one begins to claim to me that we there is he has a compensation. So thus, that is what is called contributory negligence. So where this is whereby the plentiful contributed to the loss or the injury that occurred. Then the other defense that the defendant can use is the consent, where the plentiful or claimant either expressly or implicitly consented to the risk or loss or damage. Like I gave the example on the doctor, whereby you have consented to that risk, so that can you cannot hold accountable the person who was doing the procedure. Also, an example, implicit consent to a spectator at a sports event. If a spectator is hit by the football during the game, he is assumed to accept the risk of injury when buying a ticket. So you are in a football pitch, then the ball hits you, then you say, no, they have to compensate me. No, by the time you were buying a ticket, getting into the stadium, you had consented that you're going to watch the football. So those are the defenses that you use in the unintentional tort. Then the other defenses can be that there was no duty of care. So you had no duty of care. Then like you have not been given any charge over something. Now, just because you were there, you said, why did you, my thing is lost because of you. You were not given the duty of care. Then there is a public policy over that matter. Then there is also the no damage, whereby you are able to prove that no damage was done, especially when it comes to these mechanics, the electrician, and all that. Now, many other times whereby the plentiful or someone who you take something to for repair, then that person fails to repair your machine. Then you begin to claim that no, this thing has been damaged. He has damaged my TV. But in the first place, you took it because it was not working. So that is where now the defendant has to prove that there was no damage that incurred. Then no breach of duty. There was no breach of duty that incurred. So you were not given any duty over that. Damage is too remote. So the damage that maybe one may be claiming the damage that is too remote, that cannot be justified. So that is what in the intentional tort. Those are the defenses. So we are going to look at another set of defense in one of the defenses that in the categories that I had outlined in the categories of torts. Thank you so much. Join me in the next class.